A Michigan DUI lawyer. I am in Wyandotte, Michigan this afternoon, 27th District Court in southeastern Michigan, downriver from Detroit. I am in front of the Judge Elizabeth DeSanto, who has a huge following on YouTube and broadcasts her proceedings over Zoom, and those are picked up on YouTube where she's got a massive following. A question that Judge DeSanto loves to ask people that are up for arraignment is, if we test you today, what's going to be in your system? I've objected to this, and it creates a conflict for the client. Are you going to be honest with the judge? Are you going to incriminate yourself? It creates a problem, a tension between the right to be free on reasonable bail and waiving your right to remain silent under the Fifth Amendment. Judge DeSanto disagrees with me on this. And of course, a court is permitted to conduct chemical testing under certain circumstances as a reasonable condition of bond. But to ask a person what's in their system is to ask a person to incriminate themselves. Several courts across the nation have addressed this very situation, these types of facts, and have held in many instances that this is improper questioning by the judge. In the western side of Michigan in 2013, Judge Kenneth Post was reprimanded and given a 30-day suspension from the bench when he jailed a defense attorney for instructing his client to remain silent when the judge demanded that this person up on arraignment disclose whether or not there would be something in his system. Some courts have held across the country that a person should be entitled to be completely honest with the court and engage in candor in order for the court to know and understand their situation and their predicament so that the judge can set reasonable bond. On the other hand, the federal courts don't do that. Generally speaking, the federal courts hold that if you say something at the arraignment, it can and will be used against you, even if it was the judge or the magistrate asking those questions. So there is no clear-cut, definitive answer on this, but I object to it. And despite the fact that I object to it, and I filed a memorandum that's going to be heard this afternoon, the judge is still asking people these questions.